1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်281ဦးအကျစ်ကော Appellant vs ဒေါ်ငွေသိန်း Respondent ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးသက်ဖေ Judge ဦးအကျစ်ကော Appellant vs ဒေါ်ငွေသိန်း Respondent APPELLANT Control Act 1960 Land in possession of receiver Sale of land by the original owner whether the buyer obtained good title over the land, whether the transferee can claim rent from the occupant of the premises, bona fide requirement of the premises, construction of building, held, although the suit land was in possession of the receiver at the time when it was purchased by the respondent, the original owner, THEIN, to whom the possession of the property was restored by the court subsequently, never lost her title over the property and the respondent must therefore be deemed to have obtained good title over it by virtue of her purchase from THEIN. All versus Muthia Chetty ILR 17 Madras page 501 at 504 Eastern Mortgage and Agents Company Limited and another versus Mohammed Fazul Karim AIR 1926 Kalakata page 395 at 392 refer to held also the provisions of section 55 6a read with section 109 Transfer of Property Act clearly authorized the transferee of the property leased to claim rents accruing therefrom with effect from the date of transfer, and the transferee accordingly comes within the definition of landlord in Section 2C of the APPELLANT Control Act 1960. Umya vs. Abba Qasim and 1, 1959, BLR, page 281, ASPSKR, Karuban Chadia and 1 versus A. Chokalingam Chadia 1949 BLR 46 SC Dopu versus Kodun 1955 BLR 33 HC refer to her father. The respondent has said that she really did intend to construct the building on the land and that she had the means to do so. There is nothing on the record to controvert her statement. Then there is the statutory requirement of executing a bond which should dispel any malafide on the part of the respondent in seeking a judgment of the appellant from the suit premises. Dododi versus Udaimao and Company Limited and 1 1956 BLR page 14 AC Utompe versus Mountain and 4 others 1959 BLR page 16 SC Ulukali versus Mount Mountain and 3 others 1960 BLR page 156 SC refer to Bartin for the appellant, Tontin for the respondent. Udape Judge in Civil Regular Suit number KAAW 235 of 1964 of the Rangoon City Civil Code, the respondent sued for a judgment of the appellant from a piece of land known as holding numbered 12 KAAW Deep Block numbered 32 KAAW measuring 318 of an acre under Section 12 1D of the Urban Land Control Act 1960. It was the case of the respondent that the appellant was in occupation of the premises as a tenant of its original owner, and that she became its owner by virtue of her purchase from the original owner, and also the landlady of the appellant by operation of law, and that the premises were bona fide required for construction of the building. The appellant, on the other hand, denied the ownership as well as the tenancy put forward by the respondent and pleaded that the premises were not bona fide required for construction of a building, inasmuch as the respondent was already possessed of a house nearby. On these pleadings, the lower court framed the following issues. 1. Whether the plaintiff is the owner of the suit land. 2. Whether the defendant is the tenant of the plaintiff. 3. Whether the plaintiff bona fide requires the land. 4. To what relief is the plaintiff entitled? After hearing the parties and the witnesses, the learned trial judge gave a favorable finding on all the issues to the respondent and accordingly decreed her suit. Hence, this appeal. It has been strenuously argued on behalf of the appellant that the trial court erred in coming to the conclusion that the respondent was the owner of the premises. It would therefore be necessary for me to trace the history of the holding in question. The land in dispute forms part of a larger plot known as holding numbered 12A, measuring 3.79 acres, which originally belonged to one Sudana Kanamkia, who alienated the entire plot to Mrs. Sukawandi Net Alliance THEIN on 24 August 1955 for Jet 45,000 VD Exhibit D. THEIN in time saw a portion of the plot which forms the subject matter of this litigation to the respondent by a registered instrument on 8 December 1960 for a sum of Jet 13,992. It appeared that on 22 August 1958, the Central Commercial Bank of Burma instituted a mortgage suit against 4 persons, one of whom was Mrs. Sukawandi Net Alliance THEIN in Civil Regular Suit numbered 79 of 1958 of this court. One of the mortgage properties was admittedly holding number 12A, which THEIN had purchased from Sudana Kanamkia on 8 January 1960. The official receiver was appointed the receiver of the mortgage properties. On 22 June 1962, a preliminary mortgage decree was passed on the joint application of the parties, paragraph 6 of which reads that the plaintiff and the second and fourth defendants further agreed that during the period allowed for redemption, the plaintiff will be at liberty to dispose of the properties mentioned in paragraph 12c of the plain, to wit, all that piece of parcel of freehold land situate in the registration of sub-district of Insane in lot numbered 32, Kamayo Town Quarter, Insane Township, Insane District, measuring 3 acres or thereabouts, together with all easement and appurtenances attached thereto, either wholly or in plots upon price agreed by the plaintiff and second defendant, and to apply the sale proceeds thereof in reduction of the decreed amount due by the said defendants to the plaintiff. On 28 January 1963, on the joint application of the parties, the order appointing the official receiver as the receiver of the said plot was vacated so that it might be disposed of either wholly or in plots upon the price agreeable to the parties. Then on 6 January 1964, the last and remaining item of the mortgage properties, which is not relevant to the present proceedings, was released from the possession of the receiver and restored to the parties. It is clear therefrom that the parties arrived at an amicable settlement, and the final decree was never drawn at in that suit. It is true that when the respondent purchased the suit land from THEIN by a registered deed on 8 December 1962, the official receiver was in possession of the same as receiver in the mortgage suit filed by the Central Commercial Bank of Burma. But it must be borne in mind a receiver is appointed by the court for the sole purpose of taking charge of the property, which is the subject matter of the suit, with the view to protect it until adjudication is made who is entitled thereto. The appointment of the receiver does not in any way affect the proprietary right or interest of the rightful owner. It does not have the effect of transferring the proprietary right or interest of the owner to the court or the receiver appointed by it, and the real owner is therefore under no impediment to deal with the property subject, of course. Impediment to deal with the property subject, of course, to the right of the court to manage it through the receiver. It would be of interest to refer to the decision in or versus Mutia Chetty 1, where it was observed that the terms receiver and manager are synonymous, and though the appointment of a receiver may, in certain cases, operate to change possession, yet it has no effect whatever on the title of either party to the property, which is placed in the possession of the receiver. The following observations in Eastern Mortgage and Agency Company Limited and another versus Muhammad Fazlul Karim II are also opposite. The object sought by the appointment of a receiver is the safeguarding of property. for the benefit of those entitled to it. His possession is on behalf and for the benefit of all the parties to the suit in which he is appointed, and is the possession of all the said parties according to their titles. The property in his hands is in custodial legis for the person who can make a title to it. The title of the real owner is in no way affected either in theory or principle by his appointment. In the instant case, although the suit land was in possession of the receiver at the time when it was purchased by the respondent, the original owner, THEIN, to whom the possession of the property was restored by the court subsequently, never lost her title over the property, and the respondent must therefore be deemed to have obtained good title over it by virtue of her purchase from THEIN. Now, regarding the question as to whether the appellant is tenant of the respondent, the provisions of Section 55 C.A. read with Section 109 Transfer of Property Act clearly authorize the transferee of the property leased to claim rents accruing therefrom with effect from the date of transfer, and the transferee accordingly comes within the definition of landlord in Section 2C of the Urban Rent Control Act 1960. In this connection, it would only be necessary to refer to the decisions in Umia vs. Abba Qasim and 1-3, where it was held that under Section 55 C.A. of the Transfer of Property Act, the appellant who had purchased the property from the previous owner was clearly entitled to the rents and profits accruing therefrom from the date of the sale, and thus comes within the definition of landlord in Section 2C of the Urban Rent Control Act, and that the respondents are undoubtedly tenants within the meaning of that in Section 2G. The Land Council for the appellant further submitted that since the Central Commercial Bank was collecting rents from the appellant, the lower court should not have held that the respondent was the landlord of the suit land, a receipt in the name of one Massain was filed with the memorandum of appeal, but this receipt did not say that the rent had been collected in respect of the land in dispute, or that it had anything to do with the appellant. Apart from that, the appellant had never contended in the trial court that the Central Commercial Bank, and not the respondent, was the real landlord, and he could not therefore be allowed to protect an entirely new case at this stage of the proceedings. It is settled law that a party should be allowed to win or lose on a case set out in his pleadings, and it is not the function of a trial or an appellate court to make out a case different from the one set out in the pleadings. ASBSKR, Karuban, Chadia, and 1 versus A. Choklingam, Chadia 4, Dobu versus Godon 5. As regards the question whether the premises were bona fide required for construction of the buildings. The real tests are A. Whether the owner intends to build, and B. Whether he had the means to build. If these conditions are fulfilled, the owner is entitled to a decree under Section 12(1)(d) Urban Rent Control Act, although such a decree might have the effect of ruining the tenant. It has been repeatedly held that motive is not a deciding factor in the matter of any bona fides. There is a spate of authorities over this point, and I need only to refer to the decisions in Dododi vs. THEIN and Company Limited and 1C, Utonpe vs. Mountain and 4 others 7, and Ulukale vs. Mountain and 3 others 8. In the present case, the respondent had said that she really did intend to construct the building on the land and that she had the means to do so. There is nothing on the record to controvert her statement. Then there is the statutory requirement of executing a bond, which should dispel any malafide on the part of the respondent in seeking a judgment of the appellant from the suit premises. Lastly, as regards argument that the appellant had already put a substantial structure on the land, a complete answer is to be found in the decisions in Goton Singh and 2 others versus Gowana 9, where it was held that the law has been settled since 1899 that lessors are not stopped in equity from bringing a judgment by reason of tenants having erected permanent structures upon the land lease to the knowledge and without interference by the lessor. In the result, the appeal fails and is accordingly dismissed with costs, advocate fees, Jet 51.